Major breaking news and a big win out of the state of Illinois dealing with, guess what? Cook County's gun taxes and ammunition taxes. What does it mean with the decision today by the trial court in Cook County, Illinois? Let's break down this decision and what it means, the good and the bad and the ugly, when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a top 5 finalist in the category of top voices of the Second Amendment for a 2025 Gun News Award to be held in Las Vegas in just a week or two. Looking forward to that ceremony with all of our friends in the Second Amendment community. Always a pleasure to talk to our fellow 2A advocates on social media. And as a reminder, the Four Boxes Diner is named after the 4 boxes of American liberty. That's the cartridge box, which refers to guns, the jury box, which refers to the rule of law, the ballot box, which refers to voting, and of course the soap box, which refers to the right to free speech. As Frederick Douglass said in the late 19th century, you need to have these boxes of American liberty if you're going to be a full-blown, true American citizen. Okay, folks, with that said, let's talk about this win today and some of the complexities associated with this win in state court in Illinois today. Specifically, in the case that we've covered before of Guns Save Life versus Harris/Cook County. The trial court in Cook County has entered judgment in favor of the Second Amendment plaintiffs. Guns Save Life. Now, here's the kicker, though. As you know, it is basically, as best I can tell, almost black letter law that says that targeted taxes on fundamental rights, such as the right to free speech, the right to keep and bear arms, the right to vote, targeted taxes on these activities are unconstitutional under at least 2 Supreme Court precedents. One is the Harper versus Board of Elections out of the state of Virginia. The U.S. Supreme Court said that a $1.50 poll tax was unconstitutional, even at $1.50. Likewise, in the 1980s, the Supreme Court decided a case called Minneapolis Star that said that a tax on ink was unconstitutional because newspapers use that ink to make, produce, and distribute their newspapers, and it violated the First Amendment. So with that said, it seems to be kind of a straightforward application of those 2 Supreme Court precedents to knock out a targeted tax on firearms and on ammunition sales and purchases, right? That would seem pretty obvious. And one of the best cases we have going, in my opinion, that potentially gives rise to a future U.S. Supreme Court fight and favorable ruling, in my opinion, is this case out there in Illinois called Guns Save Life versus Harris, dealing with Cook County's targeted tax on firearm sales and ammunition sales. Now, this case has been litigated for a few years now and went all the way up to the Illinois Supreme Court. Now listen carefully, because this is where it's going to get a little tricky. There are 2 theories that have been advanced by the Second Amendment plaintiffs, Guns Save Life, in the courts in Illinois. One theory is that the tax by Cook County on ammunition and firearm sales violates the basic rule that you cannot have targeted taxes on constitutional rights. Why? Because as you know, the power to tax is the power to destroy. So if you allow targeted tax on constitutional rights, you basically are saying to the government that they can impose a tax so high that they could destroy, hinder, or otherwise infringe upon constitutionally protected activity. And as we know from those cases I just mentioned, Harper and Minneapolis Star, that is a no-go zone. So the first argument advanced by Guns Save Life in this case was it violates the Second Amendment and the basic rule of you can't target constitutional rights with taxes. But there's a second one, and this is where it's going to get a little tricky. The second theory was that this law violated a Illinois state provision of the Illinois state constitution called the Uniformity Clause. Now, for all intents and purposes, without getting too geeky here, the Uniformity Clause under the Illinois Constitution basically says that taxes and fees have to be applied uniformly to items that are within the same class. That's the notion that there's got to be some uniformity as to how you apply various taxes, including sales taxes, let's say. So here, Guns Save Life and their lawyers argued the Second Amendment argument or the constitutional argument, as well as the Uniformity Clause argument. Now, on the good news front, this case was a victory because the Illinois Supreme Court ruled that the tax violated the Illinois state constitution's Uniformity Clause and therefore needed to be declared unconstitutional under the Illinois Constitution. And the Illinois Supreme Court sent a mandate back down, kind of an order to the Illinois trial court that says, enter judgment in favor of the Second Amendment plaintiffs on the grounds that the Cook County ammunition and firearms law, tax law, violated the Illinois State Constitution's Uniformity Clause. Now, after the Supreme Court, this is like a little bit of a curveball. As I understand it, after the Supreme Court of Illinois issued this order, the Cook County tried to fix this issue so the tax satisfied the Uniformity Clause of the Illinois State Constitution to fix that problem. And Illinois' position, as when this case went back down from the Illinois Supreme Court to the trial court that says enter a judgment in favor of the Second Amendment plaintiffs on the grounds this violates the Uniformity Clause, the defendants, Cook County, said, hey, trial court judge in Illinois, stop. We, Cook County, have just fixed the uniformity law problem. We have fixed the Uniformity Clause problem by the way we've modified the application and interpretation and language of this particular law, of this particular tax. So you should not enter judgment against us, the defendants, on the Uniformity Clause argument, because we've now fixed the problem identified by the Illinois Supreme Court in the appeal. Now, the trial court said that it did not have the authority or did not think it had the authority to do so because it was told specifically by the Illinois Supreme Court to enter the mandate on this ground, and therefore that is exactly what this trial court did. So the good news is that the Second Amendment plaintiffs won the case for the moment, conceptually. The downside is the way they won the case was on the Illinois State Uniformity Clause, which is good they won, but it's going to delay, at least this is my guess and prediction, it's going to likely delay a resolution of whether or not the Cook County firearm and ammunition tax violates the Second Amendment. So if you're trying to get a favorable precedent on the books that a targeted tax on guns and ammunition violates the Second Amendment, let's say, because it interferes with by imposing costs upon the acquisition of guns and ammo. If you're looking to get that kind of a precedent as a legal precedent, as public interest lawyers, if you will, then this actually kind of slows that process down because the trial court entering a judgment on Uniformity Clause grounds means that they're never going to get, or they're not going to get to anytime soon at least, the question of whether or not this law violates or doesn't violate the Second Amendment, because of course the case is now technically kind of over on grounds of uniformity. So on the one hand, remember how I've always explained to you when you're dealing with these kinds of, when you're trying to establish legal precedent as public interest lawyers, or you're trying to advance the constitutional rights, things like this, there's two things you want to look at, okay? And they're equally important. One is who wins the case. Remember we talked about this, so Mr. Rahimi, Zaki Rahimi in the Supreme Court lost his case in the Supreme Court because he had admitted to and was found to be a violent domestic thug who had taken his girlfriend's head and hit it against the dashboard and was involved in multiple shootings. So Mr. Rahimi lost his case in the Rahimi case before the U.S. Supreme Court, right, several months ago. But if you look at the way the court talked about the Second Amendment and the precedent set in terms of how to interpret the Second Amendment, is actually very favorable to the Second Amendment community because it really narrowed the scope of when you can be disarmed. And even if you can be disarmed only temporarily. So there's some very good language there. So here, again, going back to the Mark Smith rule of when you look at these kinds of cases from your perspective of what's good or bad for the Second Amendment, if the Second Amendment itself is the client, that's another way to think about this. Yes, you want to make sure that Second Amendment proponents win cases. In this case, Guns Save Life won their case But you also, equally importantly, want to look at how they won the case. So here's a perfect example of this. So we're glad that this excellent group out there in Illinois, Guns Save Life, won the case. Great. We certainly always are going to cheer for that organization over, let's say, Cook County or the state of Illinois that are a bunch of gun grabbers, right? So we're always going to cheer for them against the gun grabbers. That makes sense. We agree with that. But equally important, if not more so, is how does Guns Save Life prevail? So here, Guns Save Life prevailed on the Illinois State Uniformity Clause of the Illinois State Constitution. And that's great for people that live in Illinois, 100%. We agree. But if you're trying to use this case as a way to get the United States Supreme Court to establish, let's say, a precedent for the federal Second Amendment, for the U.S. Constitution as opposed to the Illinois Constitution, then the rationale of this case to rule against the Ammunition and Firearms Act here is not helpful, because the ruling today was specifically on Illinois state law grounds, on the Illinois state constitution. That's great in Illinois, but it has no real applicability in a real sense to the Second Amendment. You see what I'm saying? So here's an example where we're glad that Guns Save Life won the case so far, but we should not be as happy about the fact that the Illinois state courts, as of now, have ruled in favor of the plaintiffs, the Second Amendment plaintiffs, but they did so on state law grounds rather than on the federal Second Amendment grounds, which, if you're looking to use the Second Amendment to knock out laws that tax gun sales or tax ammunition sales, then outside of the state of Illinois, this does not set any kind of a real precedent, and you're probably looking at, I'm just guessing, another year or more of litigations to even possibly have the opportunity for a Second Amendment precedent to be set in this kind of context, using the Cook County ammunition and firearms tax as the law to knock it out on Second Amendment grounds. So anyway, a little bit convoluted. So this is a little convoluted, but the bottom line is I'm glad that the Second Amendment plaintiffs won this case, but I wish they had won the case on Second Amendment grounds rather than on Illinois state constitutional grounds. But a win is a win, and we'll take it wherever we can get it. And I'm sure they will continue to litigate onwards and upwards in this case. And congratulations to our friends out there at Guns Save Life. They're always doing a great job. We've seen them in other things before, and we've tracked their cases over the years on this channel, and I'm happy to continue to do so. So there you have it, folks. Hope you learned a little bit something here about the Second Amendment and taxes on guns and ammunition and the like. Make sure you subscribe, not only here on YouTube, but also on Rumble. I'm on both platforms now. Don't forget to follow me on X at 4 Boxes Diner, and I look forward to talking to all of you again very soon here at the 4 Boxes Diner.
Orders up. Table 2A.